I do something called the arbitration conversation, and in the process, I've now interviewed 79 different arbitrators. We're headed toward 100, and the same thing comes up each time. This question of these in-person versus virtual hearings, and Theo Chang couldn't be a better. He's perfect for it. Somebody who right away I'd interviewed for an arbitration conversation and just had really interesting insights to share. Also, he is with, I think you were the president of the dispute resolution section, wasn't it, in New Jersey?
No, actually, I'm the president of an inn of court in New Jersey that deals with exclusively deals with ADR. Yep.
Exactly. And he is a full-time arbitrator and mediator, has done a ton of work and does trainings also with the AAA. And I'm really pleased to have him here to be leading our first Arbi-Table talk. And thank you all for coming. Also, I'm sure Theo would say as well, please feel free to chime in different thoughts that you might have about this great debate. So without further ado, I'm going to hand the baton over to Theo. Theo, thank you.
Well, Amy and Colin, thank you so much for inviting me to do this. I'm really honored and privileged. Really great to see so many familiar faces also. And as both Amy and Colin said, please feel free to chime in because I'm really just here as a facilitator to have a discussion about what I've characterized as this great debate between the in-person and the remote hearings. But let me set the stage a little bit for you, right? We're about a year later into the pandemic. You may recall, bring yourself back to the March, April 2020 time period. You know, all of a sudden, with the pandemic as a catalyst, parties, counsel, arbitrators were now considering converting to remote proceedings using any one of the various video teleconferencing platforms that are available, right? We now know Zoom like the back of our hand, but back then we were talking about MS Teams, WebEx, Blue Jeans, and a whole host of other things that maybe are still out there, but I'm not sure a whole lot of people are using them. But in any event, we encountered some resistance, right, as arbitrators. A lot of attorneys didn't want to go to a remote hearing, particularly in the U.S. Internationally, as you may know, that's been the case for a long time. The international proceedings have done video conferencing for those hearings for a long time, primarily because of the cost and distance involved, and just the time zone differences, right? So we encountered some resistance here in the States, primarily because of two things. One, attorneys were unfamiliar with these video teleconferencing platforms. This technology was kind of throwing them for a loop. And then secondly, there was what I characterize as inertia. Essentially, the attorneys love to try cases the way they're used to trying them. They don't want to be told that suddenly they have to be a little box on a screen and then their client's not even in the same room. I had attorneys come to me and tell me, I want to sit next to my client. And in the back of my mind, I'm thinking, so what? So you can kick him underneath the table when he testifies badly? They're used to doing things the way they're accustomed to, right? But slowly but surely, we have now seen many more proceedings, convert to remote. And it's, as an arbitrator, it's super easy if the parties agree to go remotely, right? You just order it and you move on and you talk about the protocols that are necessary. It's also super easy if they don't both want to go. Then you say, all right, well, you've agreed that you want to wait until a day is safe and you can do it in person. We'll just put this on ice for a few months and check back in, right, in 6 months or so. But then we had the problem of what happens when one party decides they want to go remote and the other party doesn't. And the problem with that is that delay usually helps one party and not the other, right? There's a reason for that. And so arbitrators then began to face the question of whether A, they had the authority to do so. Can they order parties over their objection into a remote hearing? And then if you do that, then what are the protocols you're going to have for that hearing, right? If you go in person, for example, or even if you go remotely. And frankly, there was scarce authority out there, right? You may recall back in the April time period, the National Academy of Arbitrators came out with Formal Advisory Opinion 26, which basically laid out a whole bunch of factors arbitrators could look at and did conclude that arbitrators had the authority, but it emphasized that arbitrators ought to try and reach agreement with the parties on this issue. Don't try and force them into one setting or another. Then the only other piece of authority I'm aware of was later on in the year when Legaspi versus FINRA came out, Northern District of Illinois, right? Legaspi was a litigant in a FINRA proceeding, and the FINRA panel had ordered the case to be heard remotely. He then ran into court. This is not FAA now. He runs into court to file a TRO and a preliminary injunction to stop the case from going remotely. Bottom line is that the district court said that these are matters that are within the purview of FINRA's procedural rules, found no merit to any of the arguments that Legaspi raised, and so that hearing was then returned back to be scheduled for a remote hearing. There's some guidance in there, but other than that, there's not a whole lot. So the ultimate question we're going to talk about today is, have things changed? Like, where are we now? I mean, we've got mass vaccinations going along. We know a whole lot more about the virus. We know a whole lot more about protocols that can keep everyone safe and healthy. So what do they look like? What's the calculus now when an arbitrator gets hit with that question? But before we turn to that, let me ask you this. What have we learned about remote hearings now that we've had a year to try and do them? I myself have had 3 trials already. I've got a whole bunch scheduled coming up. They're mostly remote now. They're starting to schedule some in-person stuff maybe later in the fall. But we have learned, I think, a couple of interesting tidbits along the way. So I just want to open up the floor and talk about some of those things. And the first thing I'd like to talk about really is credibility determinations. That's the one I keep hearing a lot about. What do you guys think about credibility determinations over a platform like Zoom? Are you able to do them? Is it more difficult, less difficult? Are there some drawbacks? What do you guys think? Betty, go ahead.
Yeah, I think that it really, from all the arbitrators I've heard talk about this, we believe that we can do it. And we try to convince the advocates, the counsel, that we can. One of the things that I think they complain about is, and they call it credibility, but it's not really that. I'm going to use this word that's not that artful, but the whole vibe of the thing. They are used to being in front of you where they have a little flow that's going. I've heard counsel talk about how they believe they have won their cases on cross-examination. So they believe that all of this whole performance is not really what I want to say, but the whole way that they conduct the hearing, it's slowed down by video because you can't talk over each other. If you have a court reporter, that person wants you to one person talk, you're just not able to be as, what is the word? The flow doesn't go as well when you're on a video because the arbitrator stops it, mutes somebody or whatever. But all the arbitrators I've spoken with, we know that we look at more than just that person's face or their body language. We've learned to not put so much stake on a person's body language because maybe there's a reason they're not looking you in the eye. Maybe, that's not because they're not telling the truth. So I just think it's an issue that there will long be questions about it, and arbitrators will feel one way and the other parties won't be necessarily persuaded.
No, I appreciate those thoughts. The one thing that you said that stuck with me just for a second is that by being more polite, not talking over each other, people are upset about not being more polite. That's an interesting comment there. What have others experienced in terms of being able to make credibility determinations through Zoom or other like MS Teams? More difficult, less difficult? What are you looking at? Well, I'll tell you one thing. Oh, go ahead, Frank. You want to say something? You're on mute.
I would say, can you hear me okay?
Yep. Go ahead.
Can you hear me? Okay.
Mm-hmm.
I would say that I've had the same, I've done more Zoom mediations and arbitrations. I've done 2 arbitration trials. I would say that you probably have a more close-up view of a person's face on the computer screen than you do in person. And most of the feedback that people are getting in real time, if they were in the same room, is primarily coming from facial expressions than they are from body language. And to the extent there are body language issues, you can pick them up also on the Zoom. We had one just last week where the one of the parties was the husband, one of the sides was the husband and wife, and you could tell from the background that they were sitting at two different computer screens in the same room, because you could see the same door and drapes behind them. And I swear, when the wife was testifying, she answered several about 5 or 6 questions, and then stopped herself and went back and modified her answer to the first question. And I couldn't detect that she had been, I couldn't see any physical prompting like being kicked or a hand coming across or anything. But I made a mental note that I felt like somebody had coached her. You don't normally see witnesses in a trial who are being cross-examined or examined go back, 5 or 6 questions to change an answer without, being unprompted. It just does. I've never seen it happen. And so I just made a mental note that I felt like her husband had in some way or another prompted her, or somebody else was in the room that had prompted her to change that answer.
Yeah, there's certainly that risk, right? I mean, that's one of the objections I get from attorneys all the time, is that, we don't really know if that person is alone in that room testifying. We don't know if that person isn't getting text messages silently on his or her iPhone. And obviously, Frank, if you notice some funny business going on, you could ask them to, turn their camera and do a 360 for you to double check. But, if people are clever at this, they can get past you, right? So, so that possibility exists. Go ahead, Amy.
Yeah, kind of on that same topic. Michael Pitton and I were on a panel with Marcia Turnus, and we talked a little bit about this. And maybe, Michael, you also have some examples that you've used, sort of ways to make sure that there's no one else in the room. Oh, you're on mute.
Try to unmute there. Yes, one of the things that is being done more routinely is to do the 360, as Theo had mentioned, and check the room with the participants and make sure there's nobody else there. You're right, though, a clever individual could find some way of passing information one way or the other as well. I know in terms of the credibility issue also, that many arbitrators and mediators like to have the participants allow for a view where they can see shoulders. Many people feel that seeing the upper body and seeing shoulders and movement tells something a little more than just face and facial expressions, for what that's worth. Not sure about the science behind that, but that seems to be a favored type of view that many neutrals are requesting, it seems.
No, absolutely. I think I heard that too, because I think people aren't always all clever about where they place their camera. So sometimes their face is either too close to the camera or too far away, and that's why I always try and hold like a test session, in advance with all the parties and the witnesses to make sure that I know what I'm getting before the day of the hearing. You don't always get everyone to agree to do that, but if I can, I'd like to do that. Laura, you have your hand up.
So I've had the opposite problem where people won't show their faces on camera. And so I've had the attorneys say, I'm not moving forward until everybody presents on the camera. And then they would then be like, well, we got to go get them. And so they're not really there.
Nice.
Anyway.
No, that's great.
So that has delayed some of my my comments significantly, because I agree. I mean, all parties that are supposed to be present should be present and on camera, at least to the point of introductions. If I move out of a room, or you go into the breakout rooms, we understand that they might go off camera, but they have to be present and ready to participate again, at a later date. So that has happened a lot, especially in very, very contentious mediations I'm an employment attorney and I do mostly employment disputes. And it's the employee doesn't want to see that employer anymore, right? Or so we go to the joint session. So it's been very interesting to have to very politely say, hey folks, we need everybody to be present in the room at the
No, I
time.
think you're right. I mean, it's the same thing as if you were appearing in person. I mean, that'd be no way to hide behind a book or a magazine, right? You'd have to show your face, at least your face. So yeah, it's happened to me once where I had to remind someone to turn their camera back on, but I think that's the expectation, right?
Yeah, might have
Jan,
been more than once.
Jan, go ahead.
Oh, yeah, just quickly. Do any of you have experience with setting a guideline with regard to multiple channels? We're kind of dancing around it right now. Is that clearly people can have someone else in the room, which we may or may not see, but using the chat or using Slack channels? Because I find now, just from my teaching perspective, students are talking with each other in the room, out of the room, on the Slack channel. And so they've got multiple means of communicating with multiple parties. So have any of you set a expectation explicitly?
Anyone? Lori, go ahead.
Yeah, so I have a whole guidance. I send it at a page and a half. It tells you what you can and can't do. And I'm happy to share. Someone shared with me, and basically it's Zoom guidelines or WebEx or whatever the methodology. And it's no outside communications. No, look, they're signing it. Whether are they going to do it? Obviously, but you at least have a piece of paper where they're agreeing that they're going to abide by these guidelines. As well as the confidentiality aspects of it and the like. So happy to share them. As I said, someone shared them with me. I find that it makes people at least think twice before they go to use outside channels because they've signed something. And that's one document they have to sign. So it's the participants, not just the attorneys. I have a few documents the attorneys sign and then a couple that the participants, confidentiality and that Zoom guidelines.
So I issue an order as an arbitrator. I hold a protocols conference with the attorneys, and I talk through all the same things that Lori just mentioned, and I issue an order that talks about how the Zoom platform is going to be used for the hearing, which includes shutting off the chat feature. There'll be no chats. An agreement that no one's going to be texting any witnesses while they're on the stand. Another agreement that when I administer the oath, or if the court reporter administers the oath, there's going to be a second oath that's going to be administered, asking them to swear or affirm that there's nobody else present in the room, so that you get all this down. And I think it acts as a prophylactic a little bit. I'm not saying that I'm sitting there trying to enforce it word for word. I'm not even sure how he could do that. But at least it puts people on notice that these are the kinds of things that I find are shenanigans. And I won't tolerate that during my hearings or mediations for that matter.
Mm-hmm.
But I think you have to do what's comfortable for you, and you have to get the parties to sort of understand why you're raising these issues and how important it is to maintain the integrity of the hearing process, so that you can have confidence in whatever the final award is. Anybody else do something similar? Frank, what do you do?
Well, I'm on the AAA panel, and the AAA has their own set of virtual guidelines on their website, which I have adapted. And it has a lot of options. So you have to sort of pick and choose which options, and you have to work with the counsel. But I was very attuned to what Lori was saying with the Slack channel. I was this arbitration I did last week had a lot of documents, and my son works for a technology company, and I said, well, I think I'm going to split screen my Zoom so I can look at the documents on the left hand side while I'm looking at the witnesses on the right hand side. Have you tried that? And he said, Dad, I never put Zoom full screen. I always have multiple applications running, one of which is Slack, because when I'm in meetings, I'm getting Slack inquiries all the time from my subordinates and my superiors that I'm expected to respond to right away. So I think that's probably more common in the business world than any of us realize. But I do use those guidelines. I would say that one tip in terms of that I have adopted, Colin has done a bunch of training for the mediators on the Northern District panel. And the head of that panel is Tamara Lang out here in the Northern District. And both are very keen on getting in tune with the witness. And one of the things that I learned in those was to drag and drop the speaker box in the Hollywood Squares to the top center, so that you can be watching the witness while you're either essentially directly under the camera, so you can make eye contact with the witness and get that sort of a feel with them, rather than having to have them on the bottom of the screen and looking at everybody else who's just sitting there listening. So that helps me anyway in helping to really concentrate on the witness and get tuned into their credibility.
Yeah, I like what you said, Frank, because I think, I like the fact that you can do a speaker view on Zoom, and you can actually get even closer to the person than you would if you were actually in a room together. Because what I tell counsel is, in those protocols conferences, is that, well, let's talk about what an in-person would actually look like, right? We're going to have to be at least 6 feet away. We're probably going to have masks, unless we're going to erect all these plexiglass things around each other. I'm going to get a better view of someone's face and shoulders, as Michael said, if I actually have you on a Zoom channel. So that's, that militates for going remotely as opposed to in person, at least as of right now, right? Based on the safety protocols. Daniel.
I think Henry was waving his hand. I went electronic, but he went old school. He goes first.
Yeah, I have
Henry,
an
go
old
ahead.
computer that doesn't let me raise my hand on it electronically. I have a question, because actually this is really germane. I have a hearing that is set. Everybody had agreed to set at the end of the month. We have a conference room at the State Bar Association, huge conference room. And on Tuesday, I get a motion from one of the parties that cites every CDC ruling, everything you can possibly think of about the, in Iowa, we are having a spike in this, in COVID. And in a matter that's been going on for about 6 months, and I've been supervising a lot of discovery, everybody's gotten along fine. All hell is broken loose, because one party is absolutely insistent, that this is a violation of my due process rights if I don't have an in-person hearing. And, the other is like, I have the president of my company is 60 years old and in ill health and hasn't had a vaccine. And now if he gets one, he won't be immune. And, it's everything. But one of the questions so this is really germane to me, and I really love everybody's comments, but I do have just one question, and that is, if we do a video, I mean, what is there a value with doing the hearings, like where's an arbitrator, you're sitting there watching it in a gallery view? I mean, if I'm arbitrating a case, I mean, I'm just not looking at the witnesses. I'm looking at, it's amazing sometimes. I tried a case last year when a witness gave an answer that surprised the hell out of his own attorney. Yeah. And I watched just, the shocked expression on the guy's face. Told me like, oh, this is an oh shit moment for these guys. And, I really, next couple of questions may decide the case. Well, what's people's view on that? I mean, should you focus your attention, using like the speaker view, or is it helpful to, or how do you balance wanting to watch everyone in the room? Because part of it is, if you're watching everyone in the room, you may be able to hold down the cheating factor. But I'm just curious what people's views are on that.
Anybody want to take that on? Go ahead, Daniel.
What you, Henry, put his finger right on it, is we're now adjusting our, skills that we've learned over a lifetime of grade school and bar school and practicing about how to interact, and we're learning to walk and chew gum again. And one of the things is, when you're on a panel with, say, a couple of other people, you don't know what the chair, whether she sees what you see. Did she arrange her screen to have exactly what Henry was mentioning? Does she see all the faces or just one? Or is the other chair, who doesn't know how to right click his mouse, is he able to actually make a choice, or does his hearing and the experience is what the machine has set up for them, or what the last user put on the Zoom controls? So we're talking as if, and we do, but we're assuming we all have agreed that there will be a view of the hearing, and what we have to concede, and as arbitrators we should check during the hearing, is everyone can change what they see, and do you see what I see? And that's something you have to regularly check. Is and Theo, just to go back to where I was, I had a hearing in November, and we'd set it up in a large industrial complex that was empty, and we could sit 8 feet apart. And we had these long tables stretching away from me on either side, and senior counsel closest to me and the witnesses is further going away. And there was a CFO testifying, and there were witnesses in Europe and witnesses elsewhere in North America. So people were expected to look into the camera. It was natural, even with, learning how I learned to chew and walk at the same time. I was expecting the witness to be staring into his computer while testifying. And his senior attorney was doing the right thing. He wasn't looking at the witness, he was looking at my reaction. So I was at the head of this unusual arrangement. Everyone's staring at the computer, but I could ignore senior counsel looking at me until I sort of looked at the CFO, and he was dutifully looking into the camera. And then I realized his eyes were scanning. And what he'd done is he didn't know the answer, and he started to log into the database of the corporation to verify the fact. And I said, what the F are you doing? Without being that blunt. But it was just like, what are you doing? And he says, well, I'm just checking the answer. And I said, are you checking a document? He says, no. And then, of course, the senior attorney realized what was going on. His attention focused from me to him, back to me, back to the witness. And he says, I'm sorry, I didn't know this was going on. So there are those moments where we're assuming that we're all going to stare into this camera, have the same experience, and assume everyone understands it. It was in good faith, but I could tell the witness, you're not allowed to do that, even though it might have the right answer. So there are those type of adjustments I think we have to make as we go forward. And the idea of having these background screens, other than being proud of my family's artwork in the back, some people say, no, I refuse to let anyone have a screen saver in the back because it conceals the attendance of who's there. And I said, well, look, do the parties agree? And like Theo says, you call the people to a hearing and you say, look, Jaya, do you see what Henry's going to do? Well, I don't like it because Lynn is going to be hidden. Well, then, Frank, what do you say? As long as everyone sees what the other parties are going to do and agrees to it, fine. But even these little clicks of having the backgrounds, and I don't think, Jeffrey, you're that well read. I'm pretty sure that's a screensaver. These things are something that you have to just agree to, and that's the essence. Actually, Ken genuinely is well read. I can see that from there.
No, Daniel, you're absolutely right about all those things, and virtual backgrounds in particular can be very, very tricky. I don't permit them in my hearings just for that very reason. But yeah, it's always good to engage the parties in a conversation about them, I think. Going back to Henry's question, though, I think I'll just tell you what my preference is, or at least my view on it, is that I think it's similar to when you're in person, right? As an arbitrator, of course, I'm not looking 100% all the time at the witness who's testifying. I'm looking all over the place. And so you as an arbitrator, I think, have an obligation to be technically competent with the platform. And so I know how to switch between gallery and speaker, and I can adjust my frame in any number of different ways because I want to see what I want to see at the moment I want to see it. And so, Henry, you're right. If some witness is testifying on some very, very pertinent area, that's maybe when I go zoom in on speaker because I want to see what this person's face looks like when he's testifying to something really, really relevant. Also, if I see that the testimony is going south for some reason, yeah, I might switch over to the attorney and find out what the attorney's reaction is because that's really telling. But that would happen in a real trial too. So I do the exact same things as I do in person as I do on video. And I think that the more you get comfortable with the platform and the more quickly you can adjust. Like, for example, I had a case in which the parties decided to bring LiveNote in. And so I had to have the Zoom window open. I had to have the live note window open, and I sized them so that I could see both at the same time. And I have not yet gotten to the point where I don't have the right accessories and peripherals to turn my computer to branch out to have two screens. But I definitely want two screens because I want video on one and something else on the other, like documents. I just haven't gotten there yet, but that would be ideal because I want to be able to see people properly. And at the same time, if they're referring to an exhibit, I want to be able to look at the exhibit, in like a size that I can read. And as I get older, it becomes much harder. So I find I would prefer not to squeeze it all in there. Daniel, go ahead.
Do you use a Microsoft device for your laptop, or?
I do. I use a Surface Pro.
Yes. So you
yeah,
just
and I
get
need
the docking station. They're about
exactly.
$200. 2 cables, 2 monitors, and then you 3 screens, and you can see everything at once. We use one for documents,
exactly,
referral, one for view, but they're expensive but worth it.
No, you're totally right, and I appreciate that. It's on my to-do list. It's the ever-growing to-do list. I just can't get shorter. I have to go order it.
It does raise a question I have for everybody, though, because one of the things that comes up, I had actually been sort of diving in, being the sort of professor, right? So I took a chart of all the different protocols that different groups have put out, that the AAA have put out, that ICA, all these different protocols and requirements. And then what people had started to do with, the ring light and the extra monitors and all the extra sort of whiz-bang hiring technologists. But then how do you balance the technology, when you have one party that doesn't have a whiz-bang setup and the other side does? Have any of you run into this, and how did you monitor or deal with that if there's an imbalance between the parties in terms of the technology that they have?
It's a great question. It's sort of the access to justice question I was raising before.
Yeah.
Jan, did you want to say something? Or Betty?
Yeah. Betty. Go, Betty.
I was just going to say, I think we have to go with the assumption that there will be an imbalance there. People just aren't going to have access to the same way to come on to Zoom or whatever, and people are going to be jumping off here and there. So I think just the transparency, and Theo, you mentioned having the pre-hearing conferences beforehand just to discuss those things. And there's really nothing that I can do as an arbitrator about it. I can encourage them to practice, but to acknowledge that that will happen. And, I guess it happens to some extent in person. We don't think too much about it, but people come to hearings looking different ways. And, we manage that.
Right. That's right. Jan or Daniel? And then Frank?
Jan, go ahead, Jan.
Oh, no, I'm sorry. I didn't have a comment.
Oh, okay. No problem.
Thank you, though.
No, not at all. Daniel and then Frank?
There's two things. Is that someone might have a perceived advantage. So, for example, we have an administrator in New York, and the attorney in New York can, for whatever reasons, meet with the client in the same space, whereas the people from overseas cannot get into the U.S. and be with the U.S. attorney. So the compromise was that the attorney who could meet with his client agreed to meet virtually by being in different buildings, even though they could easily get together. The other party says it's not fair. There's an asymmetry that I don't enjoy. And they said, well, fine. If you will accept separating yourself so we can remove that objection, so it's not a challenge post-award, I'm for it. The other thing is, when you think of the billable hours of attorneys, and we're all reasonably priced, if you think of the people arguing, one arbitrator, and she's at $500, and the two counsels at $500, $1,500 is less than a tech package to send someone 2 screens and a docking station and say, my gift to you, use it and be on there. As long, like, I get the internet. There's a lot of places in Canada that have nice lakes and no internet, but please get close to a viable source of data feed, and we'll send you a package that your 16-year-old son or daughter can hook up for you, and you'll testify. But those are ways, is that if people realize the importance that their post-award challenge might be based on something they're not turning their mind to now, they'll be agreeable. They understand what's at issue.
Enough. Frank and then Jeffrey.
Okay, I just wanted to respond to 2 points. One, Henry's point. I don't like to use speaker view. I like to have everybody on the screen at the same time so I can read the room, including all the facial expressions of everybody at the same time. Though I do, like I said, pull the witness up to the top of the screen. I especially don't like it if it's on pure speaker view, unless I have suppressed my image, which is possible. When I'm talking, I'm filling up the whole screen and I can't read people's faces to see how they're reacting to what I'm saying. And now Tamara of Colin and Tamara fame always suppresses her image because she doesn't want to see her own face. But I haven't, I just prefer to leave everybody up and read the room. Now, on the second point, having to do with technical disadvantages, in every mediation and in every arbitration that I've had thus far on Zoom, for purposes of looking at documentary or illustrations, people are using the share screen functionality of Zoom. But there are remarkable differences in the technical ability of the lawyers to use the share screen. And not surprisingly, the younger the lawyer, the more adept they are at using share screen. The older, the more inept they are. This hearing last week, one of the two lawyers, the two lawyers were both, I think one maybe 71, 72 years old, one maybe 65 years old. So they weren't that far different in age, but one continuously couldn't get the document up on the screen. And so we're waiting time. And eventually he had to ask the other lawyer if he could pull it up on the screen because they had a common set of exhibits. I had mine, like I said, I download all the exhibits into my download folder so I can pull it up myself. If I want to see something, I pull it up on the left-hand side of the screen and look at it that way. But there's remarkable variation in the technical ability of the lawyers to show us what they want us to see.
Absolutely. Jeff?
What about the use of voice to text? I mean, you can use Cirq Court Reporter with a voice to text and have it in an actual timeline, when you start the hearing. So, I mean, you can have scrolling voice to text down the side of your screen, go back, unbeknownst to the other parties. I mean, do you put that into your agreement at all to limit that, or do you allow that, or where are you at?
What do others do? I haven't done it myself, but I see that Colin's now turned on the live transcript, so you can see that on your bottom, which is a very great feature of this platform.
Daniel, did you have your?
Yeah, I think that what the point can also be used as a way to explore ways to ignore the technology that we're being offered by these devices. Just with the hand gesture, you can go, you don't need the buttons to get people's attention. And even though you can have live text and live note, the idea is, do you actually need it with you? It's like bringing 3 kids with you. As long as they're in the back seat, you don't have to get one in the front on the road and distract you the whole way. As long as the doors are locked, they'll be there at the end. So I like live note. I like the transcript. I like all these bells and whistles. But at one point, my job, I'm hired to pay attention to what people are arguing about. And the contract signed, it's the same email and there's the same invoices. And for some reason, one says, up, the other one says down, and I have to pay attention. And if I see all these things, the less, the better. And just what you're all deciding. I like Henry, what type of screen he would like, whereas opposed Frank on the same tribunal might want something else. So this is very interesting. It basically, we're relearning how to see the world from other people's point of view. We have to anticipate what they're doing. And I think it's marvelous.
It's a great observation. If you'll indulge me, we only have a few minutes left. So I want to actually just return to the core question that Henry asked before, which is, what do you do now when the parties are in disagreement about going remotely or in person. Are the considerations different now that we're on the cusp of mass vaccination? Government regulations are starting, at least in many states, starting to loosen up a lot. Is the calculus any different for you as arbitrators? What do you think? Or what do you do? What's the best practice that you've undertaken in coming to a determination about whether to go remotely or in person?
So I've come into that problem already. And I basically, because most of my mediation, let's start with mediation, arbitrations, other people have other experiences, but with mediations, they're mostly court ordered. So I tell them to go to the judge and let them, they'll have to ask the judge, what. It's not my place to make a decision, right? That's the beauty of mediation versus arbitration. I don't have to put an order in place and tell them what to do. I basically tell them it's up to the parties' agreement until such time as the courts have made its rulings or orders that we are fully open and going, that I defer to the court's administrative orders, and the parties will need to seek guidance from their particular judge. In the federal courts, the judges have been very, very clear that they are okay and will actually order a Zoom mediation if any parties object to in person. And they, so that's what I have been doing. It's really the only way. If it's pre-litigation, it's a little more difficult, and then I have to become the mediator to mediate that dispute. But in arbitration, I think the easier way, or the way, is you have to default to the safety, I think, and the ones who don't want to go, because the courts are still saying that they don't have to go.
Yeah. Betty, and then Frank, and then Michael.
Thank you. I was just going to say, I try to talk about it early and often, just that transparency, letting them know that this may not be what we'll do at the end. We'll talk about it. We'll look and see what's happening in your state, what's happening here, if it's going to be an in-person one that you're looking at. But I agree with Lori that I know that there is a friend of mine who's an arbitrator, and he kind of defaults on, if a person wants it in person, if one of the people wants it in person, that he will go that way. But I kind of wonder about just some liability with respect to that later on, because that is not his default. My default would probably be what Lori's is. Thank you.
Frank?
Well, one of the things that I think the whole profession and the ADR profession has detected in this last pandemic year with the use of Zoom is the incredible cost savings that the parties have realized. When you think of these insurance adjusters that are located all around the United States, who are sometimes in the live world only, or forced to come to hearings and spend thousands of dollars of travel time and expense coming to a hearing. The folks that run my company, ADR Services, strongly believe that as we go into a reopening mode, that we're going to see more hybrid hearings with some people live and some people remote, because people have realized that they can get the full benefit of the experience on remote at so much less of a cost. We think that we will start seeing, even as we get into the live world in arbitration, that witnesses who have to travel will start saying, I don't really want to spend all that money to travel to fly to San Francisco, to pay some San Francisco hotel rates to come to a hearing in San Francisco. I want to just Zoom in from Kentucky or Florida or wherever I live. I had one where I had parties in San Francisco and Tel Aviv on one mediation. So if we're going to have an arbitration with the Tel Aviv party, do they have to fly all the way to the United States, or can we let them come in on Zoom? So we believe that we're going to be in a hybrid world because the clients have realized the amount of money they can save by not having to fly all around the place and fly witnesses all over the place.
Excellent point, Michael.
And arbitration is supposed to be a cheaper and more efficient way than having to go to court. So we should set up the hearings that way.
Michael?
Yeah, and just a little bit of a spin-off of what Frank's saying if there is disagreement, what are the pros and cons of a bifurcated platform where the ones who want to be in person can be in person? The arbitrator, of course, has to accommodate that. And those that want to be by Zoom or virtually allow that as well. I think the courts are being flexible with some of that, and haven't thought through the downside to that if there is any. But that seems to be a way to satisfy both. Now, having done some in-person arbitrations during the pandemic, one thing I wonder about is is the arbitrator bear some responsibility for the safety of all the participants? Somebody had mentioned liability. And is there a potential for liability on the part of the arbitrator? If the arbitrator is looked to control the proceedings, does that mean controlling the protocol that provides the safety of all participants? And whether or not there are releases to be signed on that. So I guess I just throw that out there as an open question as well and see what folks think about it.
Betty.
The person that I spoke of who said he leaves it up to the parties, he says if that person wants to have an in-person one, then it's up to them to make sure that it's all safe. But I don't buy that because I'm the arbitrator. I'm really the one who's in charge of it, as Michael's asked.
Yeah, I suppose one way to look at it is, it's within the core function of an arbitrator to determine the format of the hearing. And certainly most rules allow that discretion to be vested in the arbitrator. And so that because it's a core function of the arbitrator immunity would apply there. But it certainly hasn't been tested. I don't know any case law that protects an arbitrator on this particular score. And aside from the issue of liability, I got to tell you, on just a personal level, I don't want to be the arbitrator that orders people to an in-person hearing and then someone gets sick or dies. I just don't want to live with that personally. So liability aside, I'm just a little hesitant about going in person unless they can demonstrate to me that they've got the appropriate protocols in place. So on that score, I'll just say that my own view is that it's exactly what Betty said. For transparency purposes, have the conversation with the parties and the counsel often and early and periodically as you get closer to the hearing to make sure that you've got the right protocols in place. Regardless of whether you're going in person or remote, I think you need protocols. So you need to discuss those with the parties. And, ultimately, right, one thing that's in the way back of my mind is that an award can be vacated if you refuse to postpone a hearing and there's good cause shown. So you have to have that robust discussion with the counsel. Otherwise, you don't have a record to protect yourself from vacater later, whichever way you go, right? Whether you order it remotely or not, you have to have that sort of backup record so that there's no basis for them to vacate later if you decide you're not going to postpone it to a day when everything is safe and great. And I just want to echo what Frank said also about hybrid. I think that hybrid hearings are pretty much what we're going to see. It's not an either or proposition. You'll likely see some people, being able to Zoom in and other witnesses not. So I think those are the kinds of things I'm thinking about as I make that kind of determination that Henry's in right now. Daniel, you had something.
I see the clock. So just a quick comment is that talking about parties and the counsel, it's also the witnesses who are not controlled by the parties or counsels. Just because the parties are comfortable and they've agreed doesn't mean the witness is. And it's like it happened in a case about 4 years ago where the witness developed a travel flight phobia. And it was a person who was not under the control of either party and announced it the Friday before the Monday start. And one of the parties objected strongly and said a denial of justice. And I said, no, we'll hear her by video conferencing because her testimony is essential and it's not perfect, but we'll go ahead. So in that case, I had to take the risk of having it set aside. But again, we went ahead, the witness testified, and it's a similar thing as because counsel agree that they're comfortable in person doesn't mean all the witnesses are. And you might end up having an in-person hearing that's set in stone because of the parties and still have to use your discretion as arbitrator to patch someone in by video conference, much like a fear of flying person.
think that makes sense. Let me add one quick thing before,
And,
because I think Lori actually put this in the chat.
please.
I learned something last week that FINRA actually doesn't permit in FINRA arbitration hearings the arbitrator to ask the parties whether they've been vaccinated. And that was a surprise to me. Maybe it's because it's a governmental agency, but I certainly had that on my list of things to ask counsel, whether they're vaccinated or not. That goes into the mix of facts I would want to know. But apparently, as a FINRA arbitrator, I'm not allowed to do that. Their general counsel has made that determination, but they didn't share why in the notice. Lori, I don't know if you know why.
Yeah, I have to jump. My inclination as an employment lawyer is that it has something to do with DeSantis saying something about not being able to have COVID passports. They're starting to lean as a governmental agencies towards that stand and viewpoint. But it does say, if you read it very carefully, they don't want you to put it in the order. You have to read the language. I included it on purpose because
Okay.
it's very interesting. It says, people have been asking, and we're asking you not to put it in your orders. They're not saying that you can't ask. It's a weird wording of that particular paragraph. So I still think they're trying to encourage you not to ask, but they just say you can't put it in the order.
Got it. Yeah.
Strangely
Well, thank you everyone for this conversation. I really loved it. It was great meeting you all, and I really enjoyed hearing your thoughts on these very interesting topics. Colin and
Yes,
Amy, thank you so much.
Theo,
Yeah,
I
thanks,
want to
Brandon.
just express our gratitude for convening such a great conversation, and I want to respect everybody's time. This was a wonderful kickoff for our Arbi-Table series. Stay tuned. We already have the next one scheduled with Imre Sazlai from Loyola Law School, which also should be a great discussion. But I can't tell you how happy it makes me to get such a rich community of practitioners together to have these discussions. And I hope you found it as valuable as I did. So Theo, thank you so much. Take care, everyone. Stay well. I won't ask if you're vaccinated, but we'll hopefully see you in a month.
Okay.
All right.
Okay.
Take care, everyone.
Take
So
care.
long now.
All right.
Bye.